On the record in the matter of Edgewood Villas versus Desiree Henry, file number 22-03865LT.
Good afternoon, Your Honor. Tom Cyber on behalf of the plaintiff.
Please start your videos. Ms. Henry, are you in a location appropriate for a hearing? You're muted.
Oh, okay. Hello.
Yes, ma'am. Are you in a location where you can hold a hearing?
Yes, I'm really like I'm supposed to be trying to. I'm trying to get to work, but yeah.
Okay, well, we set this hearing date back in April, so yeah, more than enough
Yeah, I
time.
just got the mail. I don't have a mail key. I just went in the mailbox 2 weeks ago. I never got no lawyer because like you dismissed this case and then all of a sudden it got brought back up again. Like I stated before.
It was dismissed because the attorney did not appear. That was back in March, but then he
Correct.
appeared later. And so we set it for a hearing. The note that I had was that the landlord was supposed to check to see if the unit was vacant. Mr. Cyber, were you able to do that?
The landlord is on the call with us, and she was supposed to verify. She has not informed me whether or not it's vacant or not.
It's not. I have not moved out.
Okay. Today was the date and time set for a hearing for a non-payment of rent eviction. And so the parties were not able to come to a resolution. That's correct, Mr. Cyber?
I believe that's correct, Judge.
Okay. Ms. Henry, you're disputing that you did not pay your rent or that you have a lawful reason why you didn't pay your rent?
Yeah, there's a lot of things in there. My ceiling is leaking. The back door, the water comes in. There's mice all over the stove. I have mice over my stove. Every time I literally try to go down some stairs in the middle of the night, there's a mouse on top of the stove going in the thing. There's a lot of different issues. They stated that they were fixed. They went on the whatever, the little portal thing that they have, and they put that they went in my unit and fixed anything. They never went in my unit. I have cameras. I would have seen that they went in there. They never once went inside. They never came to fix nothing. Then on top of it, they're putting that I owe them all this money. I don't owe them all that money. First and foremost, on my letter that they sent me, they stated that I owe all these late fees. The late fees that I owe were for months that I paid rent on time. I paid the rent on time. They still have late fees on there that they say that I owe. Not to mention that they put 3 months of September on there saying that I owe them $1,000 and something on my thing. Yeah, I screenshotted everything that they did to me in those last couple months.
Okay, let me stop you, ma'am. Because the first portions of your statements were issues relative to habitability. Do you have any evidence or information to support your claim that you have withheld your rent because of the habitability issues?
I mean, I don't have anything to like. What do you mean? Like, I'm confused.
Well, pictures, videos.
I do have pictures and I have videos. I have all of that, but I mean, I can bring.
Okay, well then I think it's appropriate that you bring them before the court to support this claim, and so that we. Well,
that's what I was trying to do last time, but the last time when you dismissed it,
I get that. So what I'm going to do is I'm going to reset it so that you can give those copies of the evidence to Mr. Cyber. And then we'll set it. I need you to come in person and bring your evidence. Okay.
Sound great.
May 31st at 10:30.
May 31st at 10:30. Does that
That's
work
fine.
for your,
I got to be at court anyways. I'm supposed to be there. I have
I believe so, Judge.
I have a judge duty that day.
You have a judge duty that day? What does that mean?
Whatever jury that little duty? Court duty, yeah, that on May 31st.
Look, wait, hey, first of all, we're not going to call jury duty a little court duty. That is a very important responsibility, ma'am. We can.
Well, I mean, I didn't know. I'm not saying that it's not important.
Okay.
I'm saying I didn't know what it was.
We're not going to refer to it. We're not going to refer to it as just little judge duty. It's jury duty. It's very important. That's number one. Number two, if you have jury duty, you cannot be here because jury duty trumps here. Okay.
Well, that's why I was explaining it to you.
Okay.
I don't know
so
what
we're
it's
going to
called.
give you another date. because jury duty would be more important, okay?
Here. Leave them at before.
Before what?
that.
Okay. Yeah, it has to be a Wednesday. Okay.
Recording, you're being loud. Come on. Okay, that's fine. Come on. Okay, go.
Do.
May 23rd at 2 p.m.
All right.
Mr. Cyber,
Mr.
I'm
Taylor,
looking, Judge. Judge, I have a case in 63rd District that day at 2:30, at 2:15. But Judge, to be honest with you, I think Martha from Edgewood will be getting another attorney.
Edgewood is gonna get another attorney? Is that
Yes,
correct?
so that other, yes, ma'am. So Edgewood would be having another attorney handle it.
Okay, we'll leave it on March 23rd at 2 p.m. and then Edgewood's new attorney can address the timeline if they need to at the time that they appear on this case, okay?
Thank you.
No problem. Any additional matters for the record?
Not on this matter, Judge.
Ms. Henry, any questions today?
No, do I just bring that stuff down there? Like I just come down to the court office and then bring the videos and the
Yeah,
images?
you can, well, it sounds like Mr. Cyber's client's gonna get a new attorney, so you could bring it to the new attorney once we find out who that is, but you will bring that evidence to the court at the time of your hearing, okay?
Okay.
All right, you're all set, ma'am. Thank you.
Judge, I have another matter with you later on this afternoon, but at 2:30, I'm supposed to be with Judge Ward, and then I'm supposed to be with you as well at 2:45.
Sounds good.
Great. Thank you, ma'am.
Thank you. Okay, Erin Russell. Erin Russell.
conditional dismissal.
We're on the record in the matter of LG Park Place LLC versus Erin Russell. File number is 23-00139 LT. Council appearance.
Good afternoon, Your Honor. Attorney Joy Whitty on behalf of plaintiff landlord LG Park Place LLC.
And Erin Russell is present today without counsel. Is that correct, Ms. Russell?
Yes, ma'am.
Thank you. Today was the date and the time set for a hearing. My understanding, Ms. Whitty, is that the parties have entered a conditional dismissal. Is that accurate?
That is accurate.
You state the terms on the record, please.
Defendant understands that rent to retain is owing an amount of $8,160, court costs of $242.99 total. I shouldn't say possession judgment, but $8,402.99.
Your computer was, your volume was going in and out. Can you repeat the cost again?
Court costs are $242.99.
Okay, you can continue. Thank you.
Thank you. The money judgment portion will be $7,463.06, and court costs of $242.99, with a total of $7,706.05. I have the defendant's permission to sign the conditional dismissal. I have a current email address for her, and she understands she has until May 22, 2023 to pay or vacate.
Okay, Ms. Russell, you heard the terms stated on the record by Ms. Whitty.
Yes,
Okay, and you're willing to waive your rights to enter into an agreement for a conditional dismissal at this time?
yes,
Okay, so you have the right to be represented by an attorney. You have the right in this matter to proceed to a trial. You willing to waive your right to trial and your right to be represented by an attorney today?
Yes, ma'am.
Anybody threatening you to get you to waive your rights?
No.
Okay, you understand that partial performance under this agreement will not satisfy. You need to pay the amount in full by the date indicated in your agreement. You recognize that?
Yes.
You have 3 business days from today. If you leave here and determine you misunderstood any of the rights that you waived, you can return to the court and request to have this agreement set aside, and we can set this date for a hearing, okay? Do
Okay.
you have any questions?
No, ma'am.
Okay, any additional matters for the record today, Ms. Whitty?
No, Your Honor, thank you.
Thank you. You're all set, Ms. Russell.
Thank you.
No problem. Jasmine King? No appearance? Failed to appear, you can submit default.
Thank you, Your Honor. She has vacated. We will ask for a money judgment. Thank you.
Thank you. Marquita May. Failed to appear.
I'm here.
Oh, she is here. Ms. May, Ms. Whitty, did you need to speak privately? Or you already spoke?
We did.
Yes,
And
we
we
spoke.
have-
We're on the record in the matter of LG Park Place LLC versus Margarita May, file number 23-00141 LT. Council appearance.
Joy Whitty on behalf of plaintiff landlord LG Park Place LLC.
Okay, we have Ms. May present via Zoom without counsel. Today was the date set for a hearing for non-payment of rent. Ms. Whitty, can you state the terms of any agreement on the record?
Yes, Your Honor. I entered a consent judgment with Miss May and also with Parish Perkins, who is on the lease and should be on our complaint. The terms of the consent judgment are that rent is owing in the amount of $5,410. Court costs are $240.82 for a total possession judgment of $5,650.82. The money judgment portion is $4,909.52. Same court costs of $240.82 for a total of $5,150.34. The parties understand they have until May 22 of 2023 to pay or move.
We're having an issue with your connection, so you're
I'm
going
so
in and
sorry.
out.
I would happy to leave and come back if I may. Or I can submit the numbers.
Well, we had no issue there, so I don't know if there's something
Oh.
that's blocking the volume sometimes when you're speaking. But I don't know if you missed the amounts. Is that what it was?
Yeah.
Okay, if you can go over those, rent to retain amounts again, and then the money judgment again.
Sure. Rent to retain is $5,410. I think you got the court costs of $240.82. Total possession, $5,650.82. Was all that clear?
That's clear, very good.
Good. And then the money judgment, $4,909.52. Court cost of $240.82. Total money judgment is $5,150.34. Did that come through?
That did, and the rent date was what?
May 22.
Okay, very good. Ms. May, is that your understanding of how you're proceeding is with the consent judgment?
Yes.
Okay, you're consenting to pay rent to retain in the amount of $5,650.82. That includes past due rent plus court costs, correct?
Yes.
Okay, and then there's a money judgment that you're consenting to in the amount total, $5,150.34. Is that correct?
Yes.
And you're agreeing that you'll make payment on or before May 22nd or you'll vacate the property by then?
We're actually not in the apartment anymore. We're no longer there. But there's
Okay,
still occupants there that are taking 10 days to get out.
Okay, sounds good. Okay, and then, Ms. Goody, you said Parrish Perkins was living in this property?
Yes,
Okay, and this is one of the occupants, Ms. May, that is gonna take 10 days to get out?
Yes. No, he's already out as well.
Okay, sounds good. Okay, so motion to amend the complaint to add Parrish Perkins is granted.
thank you.
No problem. And so, Mr. Perkins, that's your understanding is as well that you're entering into a consent judgment to vacate or pay by May 22nd, the amount of $5,650.82.
Yes.
Okay, and there's also a money judgment total $5,150.34. You understand that?
Yes.
Okay, Ms. May, you understand that you have the right to be represented by an attorney and that you had the right to proceed to a jury trial in this matter. Did you wish to waive those rights today?
Yes.
Mr. Perkins, are you waiving your rights as well?
Yes.
Okay, anybody threatening either of you to get you to waive your rights and enter into consent judgment?
No.
Okay, you have 3 business days from today. If you leave here and determine you misunderstood any of the rights that you just waived, you can request to have this judgment set aside, and we can set this matter for a hearing. Did you, Ms. May, and you, Mr. Perkins, give Ms. Whitty permission to sign consent judgment on your behalf?
Yes.
Yes.
Okay, do you have any questions for the court?
No.
Actually, I do have a question. So what happens if they don't get out in 10 days?
Then what happens is, well, there's a writ date here, which is May 22nd. Ms. Whitty's can request a writ from the court and they can execute the judgment, remove anybody from the home if necessary, and then make efforts to recover the money under the money judgment.
Okay. I just wanted to
Okay.
ask, 'cause I don't know 100% sure if they're gonna leave in the 10 days.
Yeah, if they don't, then they'll have to be forcibly removed with the writ of execution, okay?
Okay.
Okay. Do you have any other
All right.
questions?
Nope, that's it.
No problem. Any additional matters for the record today, Ms. Whitty?
No, Your Honor.
Okay, you're all set, Ms. May and Mr. Perkins.
All right, thank you.
You're welcome.
Are we allowed to leave now?
You're free to leave. Thank you. Who's on the TCLA 3?
Hello,
What's your name?
Terrence Taylor. Terrence Taylor.
Okay, just a moment, sir.
Sir, can you hear me? Mr. Taylor?
Yeah,
Okay, very good. And then I see Shan Salter.
Yes.
Timothy.
Who is Timothy?
Oh.
Okay. Oh, I think Miss Whitty thought it was her echoing. So she said she'll be back. It wasn't her. Okay, Timothy Segurani.
Yes, we're here.
Present, yes.
Ms. Salter, are you driving?
No, I'm sitting in the car.
Okay. You have an attorney? Ms. Whitty, we were getting feedback too. I think it was Mr. Segurani causing the feedback for some reason.
I'm still hearing an echo. Are you?
Yeah, we're getting it. It's coming from whoever Timothy Sigarani.
Yeah, we're here. We're present.
Yeah, your device is causing a feedback. Are you on Zoom, YouTube at all?
Nope, just Zoom.
Okay, not sure why your device is causing feedback. I'm gonna mute you
We're gonna
for
try
now,
and
okay?
log back in. We'll probably leave the meeting.
Thank you.
Yep.
Okay, Miss Woody, did you need to meet with Miss Salter, or did you already meet?
We have not met. If I may, that would be wonderful.
Okay, I'll add you both to room 1. Is Clifton Lofton here? Clifford Lofton? Okay, Mr. Piper, no one's appeared for Clifford Lofton. You can submit a default.
Good afternoon, Your Honor. I'll submit a default with the default application as well.
Thank you so much.
Thank you. Have a nice day.
Thank you. It's not Clifford Lofton. Oh, okay. Here for Timothy Sigarani. Okay, Mr. Sigarani, do you hear me?
Yes, ma'am, I can.
Okay, that's better. Do you have an
Okay,
attorney
awesome.
at all?
We don't have an attorney. No, ma'am, we don't.
Okay. Mr. Love, you don't have an attorney either?
No.
Okay, Mr. Sigarani, is Stephanie Rose with you?
Yes, she is. Right
Yes,
here.
ma'am.
Okay, very good. Today's the date set for hearing. Typically, I put the parties in a private meeting room or let them go to a meeting room privately so they can see if they can discuss a resolution in this matter. Have you all had an opportunity to discuss possible resolution?
I have not. And to be honest with you, I broke my
so
phone again. So I could not call Dean, and I just want him to know that.
Okay, so
we are
we'll
here
have
on a
him
phone.
log into Zoom. We're gonna have him log into Zoom and you all can discuss because this matter can be resolved in a number of ways. It could be a consent judgment or a conditional dismissal. And if you all come to that understanding, then we won't have to proceed with the hearing. Otherwise, we'll proceed to hearing today, okay?
Yes, ma'am.
You don't have a smartphone, sir?
No, I don't.
Okay, we'll get you, we have iPad.
Oh, he's purchasing. You want to try to keep the house? Talk to him about staying here for a little while, and we could start coming up with some money. Please. I can't make it.
I said, Mr. Sigarani, if you should have received a request to join the breakout room.
Everybody's out of the courtroom.
Okay, Ms. Woody. All right.
Yes, Your Honor.
Did she leave? I don't see Shan Salter.
She dropped out of the breakout room as we were winding up, and I'm not sure what happened.
Okay, well, I was hoping she would log back in, but she has not yet. Did you need to meet with Mr. Taylor?
Certainly.
Okay, we'll put Mr. Taylor in room 1.
Thank you.
What happened to the St. Lines? Did we lose it?
Yeah, they was so logged up.
Okay.
Supposed to be in person for the formal hearing.
Zoom court is unmatched. Unmatched.
Get dressed, log
You
in.
gotta see what everybody's doing in their personal spaces because they don't understand it. They're conducting an official court proceeding. She can't even start her audio. Ma'am,
Yes.
can you hear us? Can you hear
Yes. I'm
us?
sorry. I had to turn my audio on.
Yeah, we noticed.
Sorry about
What's
that.
your name? What's your name?
Kaylee Schuster.
Okay, Schuster. Okay, looks like Shannon Salter is back. Mr. Bach is here for which matter?
Permit.
Oh, okay, very good. Us, Salter, when Miss Whitty is back, we will see if she needs to finish off with you. She said you guys were almost done when your phone dropped. Can you hear me, Miss Salter? Looks like she's frozen. Who's on the iPad 3?
Hi,
Hi.
that's Marquette Brown.
Nobody out there for us.
Mr. Klug is out there coming in.
Okay. Who's Victoria Young? Okay, that's 2:30. And that's the one Mr. Bach is here on?
Yep.
Okay, very good. Victoria Young?
Yes, ma'am.
You said what?
Love you too. I'm in court and y'all was like being loud. Bye.
Ms. Young, can you start your video, please?
I'm trying to now.
Okay, Mr. Bach, did you need to speak to her privately?
Sure.
Okay. It's Taylor. Hi, Mr. Cool. I thought I saw. I know which one this is. Okay, Ms. Whitty, we have, I believe, Ms. Salter back. Ms. Salter, can you hear us?
Yes, I can hear you.
Okay, very good. Ms. Whitty, were you all finished with entering into your agreement, or did you need to discuss anything more?
I think we are all set.
Okay, we're on the record in the matter, excuse me, of LG Park Place LLC versus Sham Salter, file number 23-00142 LT.
Oh, I'm sorry. Attorney Joy Whitty appearing on behalf of plaintiff landlord LG Park Place LLC.
Thank you. And Ms. Salter is present via Zoom. Today was the date, the time set for a hearing for non-payment of rent. Ms. Whitty, can you please state the terms of the agreement on the record?
Yes, we are agreeing to a consent judgment. Defendant understands that rent to retain is owing in the amount of $6,550. Court costs are $241.22 for a total proposed possession judgment of $6,791.22. She also understands, I hope I'm coming in clearly, that the landlord has requested a money judgment in the amount of $5,853.06. Same court costs for a total money judgment of $6,094.28, and that she has until May 22 to pay in full or to move.
It cut out for me during the court costs. I think you said for rent to retain 6,550, and then I didn't hear after that.
Court costs are $241.22.
Okay, very good, for a total of $6,791.22.
Yes,
And then money judgment, can you repeat that?
$5,853.06.
Okay.
Did
Okay,
you
very
need that? Okay,
Yep, I think the total I have is for $6,094.28.
yes, Your Honor.
Okay, very good. Ms. Salter, is the consent judgment how you wish to proceed?
Yes.
Okay, so you'd have to give up your rights in order to do that. But you're willing to waive your rights to enter into consent judgment, ma'am, to pay rent to retain in the amount of $6,791.22. That includes the $6,550 of rent to retain, plus $241.20 for court costs. And you're agreeing to pay that on or before May 22nd, ma'am, or vacate the property by that date?
I
We can't understand what you're saying. Ma'am, are you still there?
vacating property.
Okay, your device is
I'm sorry, I can't really-
unstable. The
Hello?
signal is unstable on your device.
I can hear you now. But I'm vacating property.
You're gonna vacate the property?
Yes.
Okay, but you're entering into an agreement though, that you're either gonna vacate the property or pay the amount to retain $6,791.22 by May 22nd. Is that correct?
Yes.
You're also agreeing that there's a money judgment that will enter against you for the total amount of $6,094.28, correct?
Correct.
Okay, and you're giving up your right to have a jury trial in order to do that, correct?
Yes.
You also have the right in this matter to be represented by counsel. You've appeared today without an attorney, and so you're waiving your right to an attorney, ma'am, is that correct?
Yes.
You have 3 business days from today. If you leave here and realize you misunderstood the rights you're waiving, you can request to have this judgment set aside, okay? We will set this matter for a hearing at that time, okay?
Okay.
Are you giving Ms. Whitty permission to sign the agreement or the consent judgment on your behalf?
Yes.
Okay, do you have any questions for the court, ma'am?
No, I do not.
Okay, any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you, you're all set, Ms. Salter.
Thank you.
You're welcome. We're on the record in the matter of LG Park Place LLC versus Terrence Taylor, file number 23-00143 LT, counsel appearance.
Attorney Joy Whitty appearing on behalf of plaintiff landlord LG Park Place LLC.
Terrence Taylor is present via Zoom. He appeared without counsel today. Ms. Whitty, how are you proceeding?
We are prepared to enter a consent judgment. I've gone over the numbers and dates with the defendant and he has agreed, if I may spell them out.
Yes, please.
Possession judgment is $4,605.29. Court costs are $240.43. Total possession judgment of $4,845.72. The money judgment is $4,047. Court costs of $240.43 for a total of $4,287.66. Defendant understands he has until May 22 of 2023 to pay in full or to move, and that the landlord can collect the money judgment if he moves out.
Mr. Taylor, is that your understanding of how you're proceeding with the consent judgment today?
Yes, I agree.
Okay, so you have the right to be represented by an attorney today. Are you gonna waive your right to representation to enter into consent judgment?
I don't need an attorney.
Okay, you're waiving your right, correct?
Yes.
You got a right in this matter to proceed to a jury trial. Are you gonna waive your right to trial in this matter, sir?
Yes.
So you're agreeing to enter consent judgment to pay the amount to retain, total amount $4,845.72. That includes $4,605.29 plus $240.43 for court costs. You're agreeing to pay that on or before May 22nd or vacate by that date, correct?
Yes.
You're also agreeing to a money judgment, the amount total $4,287.66. That's correct, sir?
Yes. Excuse me. Yes.
Thank you. You have 3 business days from today. If you leave this virtual courtroom and later determine you misunderstood your rights that you're waiving in order to enter into this agreement, you can request to have this judgment set aside. You would just need to tell the court how you misunderstood your rights at this time, okay?
Okay.
Do you have any questions today?
None.
Are you gonna
No.
give Ms. Whitty, are you giving Ms. Whitty permission to sign the agreement on your behalf?
Yes. Yes, miss.
Okay, any additional matters for the record, counsel?
No, Your Honor, thank you.
Okay, you're all set, Mr. Taylor.
I can leave?
That's correct.
Sorry about that. Bye-bye.
Hi. Simone Shannon present. Have you seen Simone Shannon?
She wasn't on there. She must have.
There was a Simone, but she's gone. I've not seen Mr. Sigarani come back. Did you all come to an agreement or it was no? Okay, well, they left and didn't come back. I'll allow you to submit default judgment. You know how to complete default paperwork, sir?
I have some of it filled out.
Oh, he can assist you if you have any questions.
Okay, thank you.
No problem. Hello, who's on the phone number ending in 5228?
Panagiotis Marcellus. I'm having some issues with my Zoom.
Citibank, but
I apologize.
he's got his video, but it's not letting him merge.
It's not letting him merge it. I don't know why. Oh, it might have did it then. Just did it. Yeah, it merged it. Sir, can you hear us?
I can hear you. Yes, I can barely hear you.
We can see you and hear you.
Okay.
We can't see you anymore, but we can still hear you.
Well, I'm sorry. Let me just get back here.
Okay, I don't see where Miss Simone has rejoined us. Let's see. Who's on the device named Peggy?
Excuse us, Judge, for being tardy. Peggy Brown with the Lansing Housing Commission.
Okay, which matter are you here for?
We're here with the Lansing Housing.
You, sir?
Yes.
Okay, very good. We have not yet started that one, so you're fine. Let's
Thank
see.
you.
Miss Whitty, no problem. Simone Shannon is not present. You can submit default.
Thank you, Your Honor. Have a good afternoon.
Same to you. Did you need his assistance?
Yes.
can he ever?
Is Mr. Bach here? So I don't see Mr. Bach. He was here. But he might have went to another court. Okay, Mr. Oh, he got rid of the other one. There we go. Oh, there's Mr. Bach right there. You're fine. Are you ready to proceed on Ms. Young?
The officer said he could be at 3:20.
3:20, that's fine. We're on the record in the matter of Lansing Housing Commission versus Kaylee Schuster. File number 23-00456 LT, council appearance.
Your Honor, Jeff Klug appearing on behalf of plaintiff Lansing Housing Commission.
Okay, and Kaylee Schuster is present via Zoom. Ms. Schuster, you don't have an attorney, is that correct? You're muted.
I'm sorry about that. That is correct.
Okay, today was the date and the time that was set for hearing or termination of tenancy. Are we proceeding to a hearing or was there an arrangement?
I was unable to speak. I wouldn't mind if she wanted to try and speak. My client is on Zoom as well.
Okay, we can get you in the private meeting room.
Yes, all right.
That's
Try
perfect.
and work something out, and if we can't, we'll come back.
You have your own device or do you need the iPad?
Not for I apologize, Judge. I didn't need an iPad.
I'm sorry?
I need an iPad.
Okay, we got it. Let me get you in room 1. Or you want me to put Lansing Housing Commission in there as well?
Yes. Please.
Ms. Young, we're just waiting for the police officer to appear. Let's see, I don't know who, John Ingman? Mr. Ingram? You're here on the matter with Shalon Lundy and, I'm sorry, Shalon Hoskins and Duran Lundy, correct?
That's correct, Your Honor. We're actually going to be moving to dismiss this.
Okay, motion to dismiss is granted. Ms. Lundy and Mr. Lundy, you're all set.
Thank you, Judge.
Thank you. on Marquette Brown. Is that a different person, maybe? Do we have a Margarita, May?
Yeah, that's me.
Okay, sounds good. Do you have an attorney?
Yes, Miss Alice, I'm not sure. It doesn't look like she's in here yet, but I did from legal aid.
What's your attorney's name?
I'm not sure what Miss Alice's last name is.
Miss Alice did not file an appearance on your behalf.
Oh, wow. I came in and filed papers that she had me, that she was working with me, and I came and brought into the courthouse last week.
I got some paperwork that you signed in pro per. Do you know what in pro per means?
No, I guess I don't.
Yeah, that means you're representing yourself.
Oh, okay. Yes, they did explain kind of what that was.
Looks like you filed a counter complaint and some affirmative defenses in the answer to complaint. Let's see.
Yes.
Well, did you get a copy of that, Mr. Doward?
I did in the mail yesterday.
This is my first time seeing it right now. And so you have to be able to respond to the counter complaint. So we'll reset the hearing so you can respond to the counter complaint.
Do I have to respond in writing?
You do, according to the court rules. May 23rd. May 23rd at 2. Yeah.
When? I'm sorry, I didn't hear.
May 23rd at 2 p.m. I'm inclined to believe this is actually going to go to hearing on the 23rd, so we can't do anything else after this. Okay, I have a blog. Okay. And I'm setting it for in person, okay?
I don't know if that will be good. I just got diagnosed with another I have health issues, and I just got diagnosed with another bacteria issue that I have that I'm on medicine for now. And I'm trying to have them switch the medicine because it keeps me vomiting all the time.
I recognize that you submitted with this counter complaint a lot of evidence. You can't present evidence if you're not here.
Okay.
That's the issue. It's not like you can share a screen or anything like that to show me what exhibits you're referencing. And so I can't meaningfully conduct a hearing where you have evidence to support your claim and or where Mr. Dowrick may come with some counter evidence and you're on a screen. I can't show it to you through the computer.
Okay, you're right, because one of those pictures that are printed is actually a video.
Correct. You need to bring that video and we can link or connect it to our screen in the courtroom. But when people have to present a lot of evidence, they need to come in person, okay?
Okay.
If that date is a concern for you, because I don't know when your medication is going to be switched, you just need to give us notice in advance and we can try to accommodate you in a different time.
Okay. I'm checking. I'm not even sure when they're gonna switch the medicine, so I'm just gonna go say, okay, yes, that'll have to work. Okay,
so we'll do that May 23rd, 2 p.m. in person at the court.
Okay, and which courthouse is that again?
We're the 54A District Court. We're in Lansing and City Hall on the 6th floor.
Yes. Okay, thank you.
No problem. You got a copy of that already, correct?
I have a copy.
Okay, do you need anything else or a notice to appear?
No, I have it written down.
Very good. Then you're all set for today on that one. Thank you.
Thank you.
Thank you. Mr. Marsalis?
Yes, I apologize, Your Honor, having technical difficulties.
No problem. Which matter are you here for?
I am here on the Citibank NA versus Nelson, Frank Nelson.
Anybody here for Frank Nelson? I have not seen Frank Nelson.
You should be a pro se defendant.
Frank Nelson was supposed to be here at 2:45. Frank Nelson is fair to appear. Let's see.
And Your Honor, if I may enlighten the court, give some background. I did check with our client's ledgers, and the occupant who did receive the debtor, the occupant sent funds post foreclosure to reinstate the property. Unfortunately, it was too late to reinstate, so that's why it was sent back, the funds. So there was a fund sent on April 21st, 2023 in the amount of $628.54. And on April 14th, the amount of $6,519.52 that was sent back to the occupant too.
Okay, well, if he's failed to appear, so default can enter. This will be the second time a default entered on this matter.
Okay, Your Honor. And I'm sorry. Actually, Your Honor, I think there's two things on this matter, because there's a motion to stay the eviction. We already have an order of possession.
Yeah, it was set for hearing for termination of tenancy, which means it was set incorrectly. Let's see here. Motion, correct. We already have a default, so the motion is denied.
Okay, Your Honor, should I upload anything to the court, or the court will enter an order sua sponte?
You can submit an order to the court under the 7-day rule.
Under the 7-day rule, okay, and then it would just order denying the occupant's motion.
Correct, the motion to
Okay.
stop eviction.
Okay, thank you, Your Honor. I appreciate it. And then should I just have my assistant email it or fax it?
Yeah, or you can email it to Judge Simmons Courtroom at lansingmi.gov.
Well, I'm sorry, what judge?
Lansing, Judge Simmons Courtroom
Oh, Simmons, okay.
at
Courtroom, okay.
lansingmi.gov.
Okay, great. Thank you, Judge. Appreciate it.
Thank you. Mr. Cyber? Nobody is outside, correct? Derlinda Kittle failed to appear.
Yes, Judge, I'm here. The Martha from Edgewood Village should be here.
Well, the plaintiff, the defendant failed to appear, so the fault can be entered. I thought that she failed to appear the last time, which was in March, but you requested a new date because you thought that there would be something worked out.
Yes, Your Honor.
Is that still the case, or do you need your client to appear first?
I need to have my client come in and do the numbers. If you would give me a minute, and I'm here at my office, I will call and get her back on.
Okay, sounds good. Mr. Clue, on the record in the matter of Lansing Housing Commission versus Kaylee Schuster, file number 23-00456 LT.
Good afternoon, Your Honor. Jeff Kluge appearing on behalf of Plaintiff Lansing Housing Commission.
Thank you. And Ms. Schuster is present via Zoom without counsel. The parties did meet. Did you come to an agreement?
Yes, Judge. We are going to enter a consent order for conditional dismissal. The defendant has agreed to vacate the premises 902 West Miller, Lansing, Michigan, and turn in keys on or before May 31st, 2023, and remove personal belongings. And if she does that, there won't be a judgment. If she fails to do that, then on the next day, we can provide no affidavit to the court without notice and ask for a judgment and a written.
Okay, Ms. Schuster, did you hear what was stated by Mr. Klug?
Yes, I did.
So the agreement, as he states it, is that there's going to be a conditional dismissal, meaning the case will be dismissed today under the condition that you would vacate the property on or before May 31st and remove all your personal belongings and turn in the key. Still,
That is correct.
okay. And you want to agree to that today?
Yes, I do.
You have the right to appear with an attorney today. Did you want to waive your right to an attorney in order to accept this conditional dismissal agreement?
Yes.
You also have the right to demand a jury trial in this matter. Did you want to waive your jury trial in order to enter conditional dismissal?
Yes.
Okay. You have 3 business days from today. If you leave here and you determine that you misunderstood the rights that you're waiving, you can request to have this consent order for conditional dismissal set aside so that you can have a hearing. You would just need to articulate to the court how it was that you misunderstood your rights, okay?
Okay.
You have to understand also that partial performance will not satisfy this. So you need to remove all of your personal belongings. Can't leave anything behind. You have to turn in the key.
Right,
by
I
May
understand.
31st. You understand that?
Yes, I do.
Okay, do you have any questions?
I do not.
Any additional matters for the record?
No, yeah, I do have a consent order for conditional dismissal. I signed my name. I didn't sign the defendant's.
Ms. Schuster, are you giving Mr. Klug permission to sign the conditional dismissal on your behalf?
I am, yes.
Any additional matters for the record, counsel?
No, yeah.
You're all set, Ms. Schuster. Thank you.
Thank you all so much. Enjoy the rest of your day.
Thank you. Thank you, Ms. Brown.
Thank you, Judge.
We had a dismissal for the 315. It was witty.
Yeah.
trustee Renisha Porter. Can you hear me? Renisha Porter. Oh, her video's, her audio's not started. Renisha Porter. John Maynard.
Yes.
Okay, very good. Mr. Becker, you're here on those matters, correct?
I am, Your Honor.
Okay, Ms. Porter's still figuring out how to use her device, so I'm gonna put Mr. Maynard in the room with you.
Excellent. I have a representative from Walnut Park out here also, if we could put them in.
Okay, I'll add Walnut Parks to room 1.
Thank you.
No problem. I thought I seen Mr. Bach, but he left again. Mr. Cyber, I don't know if your client appeared or not.
She's supposed to be logging on, Judge. She's having an issue right now. If you could give us a little bit, she'll be right there.
I am present. I think she's in the courtroom.
She was texting me, telling me she was trying to log on. Okay.
Okay, let's see. Which matter was this, Cyber was here under Linda Kittle. On the record in the matter of Edgewood Villas versus Jolinda Kittle, file number 22-03863 LT, council appearance.
Tom Cyber on behalf of the plaintiff.
Okay, the defendant has failed to appear. Today was the date that was set for a hearing for non-payment of rent. Mr. Cyber, you were waiting for your client to appear to advise whether or not the parties had worked out an agreement.
Yes, Judge. I believe Miss Martha is there, apparently. Miss Martha, have you guys worked anything out?
We have not. Okay. Okay, no agreement. Default can enter.
Thank you. Would you like us to take proofs for the record?
No, you can just submit the default and send it to Judge Simmons' courtroom at lansingmi.gov.
Great. Thank you, Judge. Have a great day.
Thank you. Same to you. Are you Mr. Nelson?
Yes, I am.
Mr. Nelson, what time are you supposed to be here?
2:45, ma'am, but
What time is it now?
I do apologize. I swear to you, you can even call it that. There was an accident. I live on MLK. I was held up, had to go completely around the block. I swear to you, that's what happened. So
We're gonna have to reset your matter, sir, okay?
Pardon?
We're gonna have to reset your matter because the plaintiff's attorney is already gone. Okay?
I do apologize, no, I mean, honestly, it's nothing I could do about it.
May 17th. Okay, we'll reset it for you, okay, sir?
Thank you very much.
Thank you. Let's see. Clock is back.
We always looking for when I take a peek at the file. Okay, fine, it doesn't.
You may. I see someone named Darche.
Yes,
What's your full name?
Darche Johnson.
Ms. Porter, can you hear us? You're muted. You get muted, Addie? Zoom is doing crazy things today.
Can you hear me now?
Yes, ma'am, I can hear you now.
Okay.
When Mr. Becker is ready, I'll get you in a private meeting room with him, okay?
Okay.
You all waiting for a hearing? What's your name?
Nigel Moore and my wife here.
Ms. Johnson, if you prefer, we could put you back in the waiting room for you to prepare for your court appearance.
Okay, that's fine.
Mr. Becker, are we ready to proceed?
We are, Your Honor.
On the record in the matter of Walnut Park Apartments versus John Maynard, file number is 23-00423 LT. Can I have your appearance on the record?
Thomas Becker, P 53936, appearing for Walnut Park Apartments.
Today was the date that was set for a hearing for non-payment of rent. At the pre-trial, the defendant indicated he believed he was going to receive some assistance through DHS. Have the parties reached any agreement?
We have, Your Honor. We've discussed it. We agree on the balances. We're showing your rent to retain possession through the month of May of $4,107. Costs of $157 for a total of $4,264.
Okay, so is this a conditional dismissal or a consent?
This is just a consent judgment, Your Honor. I'm not sure how the court wants us to go about that because obviously I can't obtain his signature.
Okay, well, if he's agreeing to a consent judgment, what's the writ date? Did you discuss a writ date or not?
We discussed the 10-day writ date of May 22nd.
Okay, so. Okay, Mr. Maynard, are you agreeing to enter a consent judgment in which you agree to pay the amount to retain $4,107 plus $157 for a total of $4,264 on or before May 22nd or vacate by that date? Is that what your agreement is?
I'm not exactly sure. We came up with an agreement whereby I would begin paying down the past debt. And as long as the payments continue satisfactorily, that I would be allowed to stay.
Well, that's not what I was just told. I'm being told that you are entering a consent judgment. That means you're agreeing that the judgment will enter against you.
Yeah, that's fine. I agree to that. Yeah, absolutely.
Right, and that you're agreeing to pay a total $4,264 or vacate by May 22nd, correct?
Correct.
Okay, and so you have the right to be represented by an attorney. You appear today without an attorney. Are you waiving your right to attorney today, sir?
For today, yes.
Okay, and you have the right to have a trial in this matter. Are you waiving your right to trial in order to enter consent judgment?
Yes.
Okay, and so you have 3 business days from today. If you leave here and you realize you misunderstood any of the rights that you just gave up, you can request to have this judgment set aside, and then you can have this matter set for a hearing. Okay?
Okay.
Lastly, will you give Mr. Becker permission to sign the consent judgment on your behalf?
Yes, I will.
Thank you. Do you have any questions?
No, I don't.
Any additional matters for the record, Mr. Becker?
Nothing further on this matter, Your Honor.
Okay, you're all set, Mr. Maynard.
All right, thank you.
Thank you. Mr. Becker, if you want to go back in that same room with your client, I'll add Ms. Porter.
Do so. Thank you. I think Ms. Porter's in, Your Honor, but I'm still not getting a prompt.
Oh, you won't get a prompt because you're already in there. You just gotta go to break up.
I think, oh boy.
Do you have anything that says more or breakout rooms?
I got it. Thank you.
No problem.
Your Honor, this is Walnut Park. Am I supposed to get prompted for the breakout session?
No, you won't get prompted because you're already there.
Okay, I don't see, I can't hear him and I don't see either one of them.
Because you have to return to breakout room.
There's no prompt for that.
You're not gonna get a prompt because you're already in there. You gotta return to
Okay,
breakout room.
the only thing I see is down in the right corner, it says leave. Is that what I want to click on?
Nope, you should see something that says breakout room.
I do not.
You have a section that says more.
Yes. Just says stop incoming video.
No, but the bottom
Okay.
of your screen on a computer, you should see breakout room.
Yep, I got it.
Yep,
I got it. Thank you.
thank you. Hi, Ms. Till.
Good afternoon, Your Honor.
Ms. Till, I don't see you on my docket.
I had faxed in an appearance to the court this morning for Nigel Moore, Cedar Place Apartments versus Nigel Moore.
Oh, okay, sounds good. They're in the courtroom.
Yes. Is the attorney for the plaintiff present?
They have not appeared at this time.
Okay, perfect. Thank you.
No problem. We're gonna put Mr. Freeman, Mr. Asphalt in the room with Ms. Till. Why does it say Renisha? Renisha Porter. Who did that? Renisha Porter's in the, who named her Renisha Porter?
Is that her name?
No.
What on the iPhone?
No, that was Darche.
Oh. Oh.
Renisha Porter is in room 1. Yeah, we gotta rename her. That's Darche. Renisha Porter's in room 1. And then after he's finished with her, then Miss Johnson can go in the room with Mr. Becker. Ms. Till, I'm gonna put you in room 2 with Mr. Asphalt. Okay. Mr. Mashni?
Yes.
Okay, I have Miss Kanja Sintish here. Did you need to speak to her privately?
Yeah, there's a co-defendant. I think that was a problem. We had a settlement last weekend and the co-defendant didn't want to go through with it apparently. And so I can speak with her privately.
Is that Kamel? No, it's Kamel. You said the co-defendant didn't agree. Who's the co-defendant?
Well, he agreed on the record. Wilfred Nagunaki, did I say that right?
My records reflect he never appeared.
Yeah, he appeared on the last hearing. This was the third hearing. He appeared on the second one, the middle one.
Okay, I'll put you in a private meeting room. Is he
Okay.
here today?
I don't see him, no.
Oh, well, then it's a moot point because this will be the second time he failed to appear, but I'll let you meet.
Okay, thanks.
Mr. Bach, are we still waiting for the officer?
No, he's here. I was trying to get into a breakout room with Miss Young.
Oh, the officer's with you?
The officer was here and he left.
Okay, let me put you in a private meeting room with Miss Young. Room 4. Miss Young's room 4. Okay, Ms. Till and Mr. Ashford, are you ready to proceed?
Yes.
Yes, Your Honor.
On the record in the matter of Cedar Place Apartments versus Nigel Moore and Kathy Jones, file number 23-00438 LT, council appearance.
Christopher Asphalt, 53129 on behalf of the plaintiff.
Felicity Till, P 83961, appearing on behalf of the defendant, Nigel Moore.
Okay. The parties of Nigel Moore and Kathy Jones are present in the courtroom. The parties, you can have a seat, have met. Have you come to an agreement?
I believe we have, Judge. Ms. Till is advising that Capital Area Housing has approved them for the arrears of $1,495.90, and that apparently they will be cutting the check for that amount. Are they sending it directly to us, Felicity? I forgot to ask you that.
I believe so, yes.
Okay, so based on that, Judge, I guess we're requesting can the court give us like a 10 to 14 day adjournment? And if we receive the check or at least receive confirmation from Capital Area that they are sending it, then we will just simply dismiss this case.
No problem. May 24th at 2:30. May 24th at 2:30.
And that will be by Zoom if required, correct?
Correct.
Thank you. All right. Thank you, Judge. I'll be in touch, Felicity.
Thank you.
Thank you. You're all set.
All right, Mr. Moore, I'll be giving you a call.
Thank you. Thank you.
All right, thank you, Judge.
Sorry. Thank you. We'll get you a copy of your notice to appear.
Okay, so we can go.
Yeah, we'll give you a copy of your notice before you leave, okay?
Okay. You want this to split back? Okay. Want me to still keep my phone off, right?
Yeah, until you leave the building. Ms. Till is gonna give you a call, I believe, in a moment. Ms. Porter is attempting to fix her device. So I'll put you in the meeting room with Ms. Johnson. Mr. Becker, Ms. Johnson is in your room. If you want to return to breakout room, you'll see her there.
I think we have an agreement, but,
She's trying to work out on her computer, so I put you in the room with Ms. Johnson. Ms. Porter, can you hear us?
Yes, now I can hear you.
Okay. Mr. Mashni is returning. Ms. Sentish, are you ready to proceed?
Yes,
Yes.
Your Honor.
Mr. Mashni?
Yes.
Okay, we're on the record in the matter of Raw Realty LLC versus Wilfred Maganika and Candon Kamel, also known as Candace Sentish. File number here is 23-00375. Council appearance.
Raymond Mashni appearing on behalf of the plaintiffs, Your Honor.
Thank you. Today was the date and the time that was reset for hearing. Last time we were here, April 26th, parties were requesting time to enter an agreement so that they were going to execute a deed in lieu of forfeiture. And once that was signed, the plaintiff would dismiss. And it looks like there was some level of objection. But we're here today and it's just Ms. Sentish, correct?
Yes.
Okay, how do you want to proceed at this time?
Well, I would like a consent judgment against Ms. Sanchez. She actually signed the deed in lieu of forfeiture, so it would, and I request a default against Mr. Naganaki. The default would state that for the land at 1437 North Martin Luther King Junior Boulevard in Lansing, there is 47,200 due, and under paragraph 3, I just put 47,200 total, and that's less than 50% of the purchase price. And if that amount is paid in 90 days, the total amount, then an order of eviction may be issued. And then under further orders, I'm going to request that Ms. Sanchez already signed the deed in lieu of forfeiture and waives her right of redemption.
Okay, so if she's already signed, which is what the original agreement was from last week, why are you no longer just dismissing against her?
Well, I was just wanted it. I'm just looking forward as to how a title company is going to give us problems because I got a judgment of possession after land contract forfeiture and it doesn't address hers. I just wanted her to not acknowledge in here. I guess it doesn't need to be part just under the further orders. That we can put a dismisses against her. I think if that deed, and she showed me the deed. I've been trying to get a hold of my client. She showed me the deed and they met and he paid her some money and she signed the deed. But I would just try to.
This is essentially, as to her, I would assume it, or I would configure it as a conditional dismissal because the statement at last hearing was that if she signed the deed in lieu of forfeiture, then you would dismiss. So that means if she didn't sign it, then obviously the dismissal is a moot point.
Okay. Well, then if I could take the default on those terms against the co-defendant, And if I could just get a week, once I confirm that with my client, I'll submit a dismissal as to her, and we don't have to come back.
Okay, sounds good. That is granted. Default as to Magonika and conditional dismissal as to Ms. Kamel. And Ms. Kamel, we went over your rights last week that you would be waiving, and we went over the agreement, and you're still willing to enter into that agreement? Ms. Sentish?
Yes, Your Honor.
Okay, you're still willing to enter into the agreement to sign the deed in lieu of forfeiture?
Yes.
Okay. Okay, so that will be granted, Mr. Mashni. I don't see a reason at this time to set another court date unless you find out she did not sign it, then you can set it. You really don't have to, you can submit a default at that point.
Sure, I will submit. I trust her that she told me she signed it and my client paid her, so I'll just record that deed and I will submit a judgment. Is there an email address I can send it over to?
Yes, Judge Simmons Courtroom at lansingmi.gov.
Thank you. We'll get that right over.
Thank you. You're all set, Ms. Sentish.
Thank you, Your Honor.
You're welcome. We're on the record in the matter of Walnut Park Apartments versus Renisha Porter, file number 23-00422 LT. Council appearance. What did I say? I'm sorry, wrong file. We're on the record in the matter of Edward Rose Associates, also known as Waverly Park versus Victoria Young, file number 22-04161 LT. Mr. Bach's not here anymore, though. He's in the building, though, isn't he? Yes. You should have told him to unlock your account. Council appearance, please.
Yes, good afternoon, Your Honor. Ronald Bach here for plaintiff.
Okay, and then we have Victoria Young present via Zoom. Today is the date that we reset the hearing for an eviction for termination of tenancy. At our previous hearings, Ms. Young indicated that the allegation that there was a shooting in her apartment didn't take place at her property, that it was at a neighboring unit. And so the court adjourned this to require the plaintiff to provide evidence in support of that, because there was none provided with the complaint.
Yes. Me?
Yes.
Ronald Bach for Edward Rose Associates. The officer was here. He had an unredacted report in his hand. And the maintenance man, Mike, he saw Ms. Young walking with the alleged shooter. But the gun was recovered from an apartment across the hall from hers.
Are you giving testimony or argument?
No, I'm just letting you know where we stand.
Got it.
So we were trying to see if we could just agree to a paid state judgment or conditional dismissal. She didn't want to agree to that because she's numerous months behind. So it would be our request to convert this to a normal non-payment case.
That's not the reason that I didn't agree.
Ma'am, you can speak at this time. Why didn't you agree?
I didn't agree because they done tried to slander my name on top of me having to go to a different city and losing my pet because of the stuff that they said that I did that never happened. Like, what?
If the officer was here with the unredacted report, why wasn't it brought to me? Because that's what I ordered. I ordered an unredacted report.
My apologies.
Yeah, I know you weren't the
I
previous.
wasn't allowed
You
to
weren't.
touch it.
You weren't the previous attorney on the.
No,
on
I
this
wasn't
case.
allowed to touch the report. He said that he recovered the gun from the apartment across the hall from hers. He said he saw her walking with the guy who had the gun.
Does it mean that the shooting took place in her apartment?
Shooting took place on the whole other side of the complex, but they walked, she walked with him.
So then what she stated was that the shooting did not take place in her unit, was accurate.
It didn't take place. It was, she was with that shooter. And they walked towards her apartment. He was a guest.
A guest of her residence, you mean?
You don't know. And then when he saw her walking with the guy who had the gun,
If he was a guest in my residence, he would have been in my home.
but the gun was recovered from.
So an eviction was initiated against her because there was a shooting and she was seen walking with the person who allegedly was shooting or allegedly had a gun?
Well, he had a gun.
Okay,
He did have a gun.
okay.
There was a
But
gun.
there's no,
recovered.
but now all I have is you telling me that someone had a gun. I didn't adjourn this more than one time for someone to bring me some evidence. And I still don't have any.
Well, Your Honor, we were of the opinion that we could not pin the shooting on her. And that when we were of the opinion that because she was walking with the shooter, the gun was recovered from the apartment, her apartment. Come to find out, it was right across the hall from her. So we weren't going to proceed with that case. Now it's
Gotcha.
just about a payment issue.
Okay,
But she wasn't able to pay. She was locked out. Waived the late fees and the costs, which seemed pretty normal. Now it's just a matter of paying your rent.
okay, and now the allegations, well, she hasn't paid her rent.
But she was locked out of the system because of the.
They purposely locked me out of my account.
That's why
She
we
couldn't
waived-
pay the rent.
That's why we waiving the late fees.
That's only reasonable, don't you think?
That's why I know I said.
Yeah,
that.
that's
why I
the
said. that.
very least that could happen.
Well, yeah,
Okay,
and the costs.
and, well, yeah.
I understand.
That's not, you're not doing any favors, I
No,
don't think.
no,
in
no.
that.
All I said was fine. Just pay your rent. You
Okay,
can stay.
and so she does
We're
not want to pay her
apologizing.
rent, or what is it, Miss Young, what is the issue?
I literally have, like, y'all, they pinned something on me, and I've literally been suffering since they locked me out my account for something that I didn't do.
I completely understand your frustration, ma'am. But as it relates today, it relates to this eviction, I'm dismissing it. I just want to be clear. Because I've adjourned this multiple times so that it can be addressed and giving the plaintiff multiple opportunities to provide evidence. Typically, if you're going to file an eviction due to a safety concern or hazard, then they should have attached a police report. Nothing was ever attached. So I was more than gracious in resetting this multiple times. The attorney who was previously on the matter, this is obviously not your issue, Mr. Bach, because you weren't here.
I was here a
could've-
couple weeks ago, but yes.
Right, he could have subpoenaed the witness.
He was
But
subpoenaed.
the first time was February 28th, though, and you weren't here. Actually, February 15th was the first time I was here, and then February 28th, and then March 15th, and then April 26th. So you weren't here all of these times. And so the attorney was advised in February that I wanted the witness here if he could not get me unredacted copies of a complaint because of the claims that she very clearly articulated, which is that this was not a shooting in her unit. And that's the basis upon which he told the court that he was seeking an eviction. And so I don't believe that the plaintiff is able to sustain their burden as it relates to that. So this case is going to be dismissed. If you want to pursue a eviction against her for non-payment of rent, you can feel free. She may have a counterclaim. It sounds like that she was locked out of the property or locked out the ability to pay because of this incident. So maybe you all can work something out outside of this. But as it relates to this case, my time with this case is ending today, because I'm dismissing it. Okay.
Understood.
You're all set on this matter, ma'am.
Okay, thank you.
Mr. Becker, are you all set in the breakout room?
I believe we are, Your Honor. I think we lost Miss Porter. She said her phone was going to die. But I think if I think we have a resolution we reached, that we had just adjourned this, I think we could do it out of court.
Okay, sounds good. We're on the record in the matter of Walnut Park Apartments versus Darshey Johnson, file number 23-00425 LT. Council appearance.
Thomas Becker appearing for the plaintiff, P53936.
Okay, and then we have Ms. Johnson present via Zoom. Today was the date and time set for a hearing. Council, how are we proceeding?
Your Honor, we've had an opportunity to discuss the matter. We've agreed that the amount of rent to retain possession through the month of May is $5,006. The cost of $157 for a total of $5136. We've agreed to enter into a conditional dismissal whereby the defendant would pay the sum of $2,500 by May 12th. He would pay a full month's rent of $598 by May 24th. She would pay June's rent.
No, Mr. Becker, that was not right.
It was $898.
$898 on by the 24th.
Oh, I thought that's what I said. I'm sorry. My
It's
apologies.
okay.
Okay, repeat that. It's gonna pay $2,500 by May 12th.
$898 by May 24th.
$898 by May 24th.
Additional June's rent of $898 by June 10th. And she would pay her rent current by the 10th of each month going forward. Further, she would pay no later than June 23rd, an additional $500 towards the outstanding balance, and an additional $500 before the 23rd of each month until that outstanding balance is paid in full.
Okay, that's a lot of terms, so I'm not gonna repeat all of that. Did you hear all of that, Ms. Johnson?
Yes, ma'am.
Okay, and are you disputing that those are the terms of an agreement that you're entering into?
What you mean? Like I agree to them. I agree. I agree with them.
Right, but you heard the terms that he indicated, that you're gonna pay $2,500 by May 12th. You're gonna pay a full month's rent of $898 by May 24th. You're gonna pay a full month rent by June 10th, and $500 on the past due balance by June 23rd. That's all an agreement that you made?
Yes.
Okay, and you're willing to give up your right to be represented by an attorney in order to enter into this agreement for a conditional dismissal?
Yeah. I agree to everything.
Are you sure?
Like, I'm sorry, but what do you mean? Like, what do you mean?
Okay, so they're agreeing to dismiss the case on the condition that you follow the terms of the agreement. So the case will be dismissed today if you agree, and then you would
Yes, I
follow
agree.
that agreement. Okay, and but you have to give up rights before you can enter into the agreement. So that's what I'm asking you. Are you willing to waive your right to be represented by an attorney in this eviction matter in order to enter into conditional dismissal?
Yes.
And are you willing to waive your right to a trial, because you did have a right to trial in this matter, in order to enter into this agreement and have this case dismissed upon the condition to pay?
Yes.
Okay, you understand that partial performance will not satisfy this agreement. You have to pay in full. You understand that?
Yes, ma'am.
Okay. You have 3 business days from today to return to the court. If you misunderstood any of the rights that you just waived, you can request to have this agreement set aside, and then we would set it for a hearing. Lastly,
Okay.
do you give Mr. Becker permission to sign your name to this conditional dismissal on your behalf?
Yes, yes, ma'am.
Okay, do you have any questions?
No, ma'am.
Okay, any additional matters for the record, council?
Nothing on this matter, Your Honor.
Okay, Ms. Johnson, you're all set. Thank you.
Thank you. Have a good night.
Same to you. And then we'll reset Ms. Porter and hopefully you all have that resolved off the record.
We'll do so. Thank you, Your Honor.
Let me give you a new date.
Oh, sure.
May 17th at 2:30.
Okay, great. Thank you.
Thank you. Ms. Young left again. I think. So, yeah.